Hi everyone, welcome to week 7 of the class. We're going to continue our discussion on race in the Supreme Court, and today what I'm going to do is talk about the two Brown decisions of the 1950s and then move ahead and talk about the affirmative action cases that have been handed down in the last 30 years. I'm going to talk about three in particular: the Bakke decision of 1978 and then the two court decisions in 2003 that dealt with the Michigan Law School affirmative action policy as well as the University of Michigan undergraduate program affirmative action policy. So let's go ahead and get started. And once again, I'm going to be referring to the document I sent, the PDF file of the excerpts from Supreme Court opinions. So you might want to grab that while you watch and listen along. Okay, so let's go ahead and get started. Now, the first case I want to look at is the famous landmark decision, Brown v. Board of Education, argued and decided in 1954. I think many of us have a sense of what the Brown decision was about. I think we understand that it was a landmark decision ending desegregation in public schools all across the country. I want to point out a couple of things about the case that I find of interest, and certainly if you have any issues or any questions about the case, you should get in touch. But this is on page 164 of the document that I sent you. You can see the excerpt of the summary of the case and the background to the case. If you look at page 164, you see that the court and Justice Earl Warren, Chief Justice Warren, who wrote the unanimous opinion, is talking about the 14th Amendment and when it was drafted in 1868. And if you read here on the second column, the court is talking about what the framers of the 14th Amendment were thinking as it relates to public education when they drafted the 14th Amendment. Now, this is very important because in Supreme Court jurisprudence, there is a philosophy or a theory which is known as original intent. And what that means is that the court is trying to find the basis upon which to rest their decision. And many of the times, they will go back to the original framers of the Constitution or of the constitutional amendment that they are basing their opinion on and try to figure out what those people meant and wrote at the time. So what you see Justice Warren doing here is trying to figure out where the field of education stood in 1868 and what the Congress, when it ratified the constitutional amendment, believed to be the place of education. Warren goes through a whole sort of series of rationales for this, and he comes to the problem, and this is at the bottom of 165, first column, the last full paragraph. He says, in approaching this problem, that is the problem of trying to figure out where education stood in 1860s, we cannot turn the clock back to 1868 when the amendment was adopted, that is the 14th Amendment, or even to 1896 when Plessy v. Ferguson was written. We must consider public education in the light of its full development and its present place in American life throughout the nation. Only in this way can it be determined if segregation in public schools deprives these plaintiffs of the equal protection of the laws. So, in other words, what the court is saying is that when the 14th Amendment was ratified, and even when Plessy v. Ferguson, which we looked at last week, was decided, public education had a much different impact and a much different place in American life than it did by the 1950s. Warren rationalizes this by saying, look, now we have compulsory education. In the 1860s and even to the extent in the 1890s, we were in an agricultural society. Education was less necessary for people to make a living. Children were working on the farms. But as you move through the industrial age and as you move into the middle decades of the 20th century, education is key. And therefore, we have to look at this case from the prism of where it stands today, not in terms of original intent. So the court is searching for a rationale for its decision, and that's what I think you need to understand here. On your discussion board, we're going to be talking about the famous Kenneth Clark Dahl tests, and so what the court is doing here is trying to figure out a way to understand if segregated schools has an impact on children of all races, certainly, but most importantly of the African American race. Look at the second column on 165. The court, in the first full paragraph there, says, "We come then to the question presented, does segregation of children in public schools solely on the basis of race, even though the facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does." A shockingly bold statement, because for the first time you have one branch of the federal government, the Supreme Court, saying that segregated schools creates an inherent inequality between the races. Now, if you jump down to the bottom of 165, the second column, you see that the court is quoting from a lower court decision. You see that inset there, and I just want to read this because if you read closely the last chapter of my book, Between Freedom and Bondage, I refer to this very point about sort of the damaged psyche mentality that goes into this. And this is key because you read Darrell Michael Scott's chapter last week, and he's talking about something similar. So the court, quoting a lower court decision, says, segregation of white and colored children, now listen to the language here, segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of law. Segregated schools impacts Negro children, African American children, in a way that has a detrimental effect. Notice what the court didn't say. It didn't say that segregated schools, segregation of white and colored children, has an impact on all children. It's a very interesting omission, if you will, because what the court is assuming is that perhaps segregated schools do impact children of color, but we're not sure whether or not it has an impact on white children whatsoever. And what I think is going on here, and this is what Darrell Michael Scott is talking about in his chapter, he mentions the Kenneth Clark Doll test, is that we move from the Plessy decision of 1896 to the Brown decision of 1954, we have a change in emphasis and a change in thinking as it relates to race relations. Remember back in the Plessy decision where the court said Homer Plessy is not entitled to the reputation of being a white man. His value as an African American is lower and less than the value of whiteness, of property inside a white person's body. And so the emphasis in Plessy is all on the value of whiteness, and Homer Plessy shall not be allowed to sit next to a white person on a train car because he would be devaluing a white person's property. Fast forward to 1954, and by the court's own logic and own reasoning here, you have the court saying, now we're focused not on the value of a white person's property, but on the damaged psyche of the black child. And if you take this logic one step forward, if in fact segregation has damaged the psyche of black children, well, what's the remedy? How do we rectify that problem? And the court seems to insinuate, well, all you need to do is to take black children and put them in the classroom with white children, and their psyches and their self-esteem and their perceptions of the world and themselves will be made whole. It's a very interesting intimation. I'm not saying the court is coming out and saying it, but it's underneath there, that all we need to do to rectify the damaged psyche of black children is to send them to school with white children. Because the court doesn't in any way reflect the idea that white children, that all children are have some type of detrimental impact from the segregated schools. So the court in Brown decides and concludes unanimously that, and this is at the top of page 156, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal, and therefore they must be desegregated. So the court, in a landmark decision, says that segregation only in public schools now, not in train cars, not in theaters. They didn't take the more bold step of saying that segregation is inherently unconstitutional in all aspects of American life. They were only asked to rule on education, and yet they decide that segregation, the separate but equal facilities in education, are unequal.